Welcome to Who's Point. I'm Alan Hu, and I have today with me Professor Simon Young from the Hong Kong University. We are old friends, and I've worked closely through him with the Hong Kong U Law faculty. And today we are going to discuss the international narrative on Hong Kong's national security legislation. A lot has been said by various governments, a lot of actions have been taken by various governments and their parliament and their senate. And the main thing with the people of Hong Kong is that it seems that they haven't really engaged the people of Hong Kong on the issues that they want to address with the Hong Kong government or with the central government. One of the issues is, of course, the British government, as I have talked about previously, alleged that China is in breach of the Joint Declaration by enacting the national security legislation because it takes away the right of Hong Kong to enact national security legislation under Article 23. So they're basically saying, well, Article 23 says you allow the Hong Kong government to do it. So how come you've done it now? So basically, that's in breach of the Joint Declaration. Well, I've told you last time that that's not in the Joint Declaration. There's no such mention about what China can or cannot do with national security legislation. The only point is that they expect, if it's silent, the international norms should apply. Now, the point here today is this. There's no repeal of Article 23. Read the national security legislation. It actually works within Article 23. The point is that in the last 23 years, the Hong Kong government hasn't been able to pass any legislation on national security. And not only that, that the local legislation left behind by the British colonial government, and which passed, being adopted as a result of the handover by the basic law of those legislation that can come into effect after the handover, like, as I said, the crimes ordinance, and within it, offences like sedition, and so on. Again, the Hong Kong government wouldn't use local legislation because they say it's out of date. So basically, you're left with a vacuum. And then what happened is that we see the events last year, where protests, which started peacefully in the beginning, degenerated into extensive violence and damage to public property, violence towards people who don't agree with the views of the protesters, shouts of independence for Hong Kong, revolution for Hong Kong, desecrating the national flag, attacking the national emblem on the central government's office in Hong Kong. I mean, that would be behavior in any country, Western or otherwise, would not be tolerated. And there will be laws to deal with it. Now, what would the central government do? They have a runaway situation with law and order in Hong Kong. The PLA was not sent in. The Hong Kong police were highly stressed in that situation, which is something that exploded in society, which they are not really that equipped or prepared for or had any warning about. And then how do they deal with it? So the central government didn't send in the PLA, as you would think a totalitarian or a regime that has always been lambasted by the West not to work within their standards, up to their standards, would send in, they would think, the PLA simply to quash it down, like the British government sent in troops to Northern Ireland when violence erupted, right? Why can't troops be brought? No, they didn't do that. What they do was to quickly try to get a law passed in the NPC, the National People's Congress, and only for those offences which are needed. It's not a wholesale piece of national security legislation. It addresses certain aspects which, in the view of the central government, and I believe the Hong Kong government, is necessary to deal with the situation on the ground. And so the first thing is that there's no repeal of Article 23. It is working within Article 23, but that which has been delegated for 23 years hasn't been acted by the delegatee, which is the Hong Kong government. So the central government acted. And you recall it is a state of an emergency in Hong Kong as far as the central government's concerned, with things happening in Hong Kong last year, just before the COVID. And therefore, the legislation that comes in is part of Article 23, and it also says expressly that the Hong Kong government should use due diligence to enact the other parts of Article 23 on matters which are not covered by the national security legislation. So it works within the framework, not repealing it. And I'm amazed that a government so sophisticated and mature like the British government would not even look at the relevant documents before they speak out. For example, there's mention of an express adoption of Article 39 on international covenants, which I'll ask Simon to talk about in a bit. But my point is that Article 23 is very, very valuable to Hong Kong. And I said on the previous occasion that I actually worked with the Bar Association with Daniel Fung to convince both governments to let Hong Kong have jurisdiction over national security offences. It's not legislate. There's nothing much to legislate on offences like treason, not disclosing official secrets, sedition. It's there in most countries, Western countries. Take any country. These are not something which is that complicated in offences against the state. But the point is who has jurisdiction. That's the sticking point. People laud Hong Kong because of its rule of law. And that's why the courts enjoy a strong reputation within the common law world and internationally. People in Hong Kong, International Financial Centre, have transactions which must be litigated by the courts. Behaviour which amounts to crime are prosecuted in the courts, right? And this is the main thing, that the courts have jurisdiction. And this is the important point, that China will let a territorial government like Hong Kong have jurisdiction over national security legislation. And I'll mention one jurisdiction that Simon hails from, Canada. It also has one country, two legal systems, one continental, one common law. One speaks French, the other speaks English. But is there different national security legislation? Can Quebec enact its own national security? No, it's the same all over Canada. So I think there is quite a bit of good faith by the central government in allowing Hong Kong's courts to have jurisdiction over national security offences. And this is the most important point, and being that at the top of that judicial system is the Court of Final Appeal. Then you have yet another feature, which is very uncommon in common law jurisdictions, even in Canada. Which common law jurisdiction will invite other judges who are not nationals of your country, who are not even residents of your country, and the laws that they will interpret will not really apply to them because they're just coming here to give a judgment, then they go away again, which is very unusual for judges. Normally, the law governs everybody, and it normally will be judges of that country who sits in the highest court. Yet, in the basic law, the central government expressly, and not in the John Declaration, especially allowed our request, I think it was our first Chief Justice's request, that in the drafting stage to allow eminent judges from common law jurisdictions like England, Canada and Australia to come and sit in the Court of Final Appeal in Hong Kong. And not just on normal domestic commercial transactions, on important cases like Ng Ka Ling, right? Right of abode. You have Lord Mason here, to sit on important basic law cases. I would have thought that with this system, the British government should be encouraging the two of their leading judges sitting in the Hong Kong Court of Final Appeal, Lord Reed, who's the president of the British Supreme Court, and Lord Hodge, who's the deputy president of the British Supreme Court, who sits on our Court of Final Appeal. The British government should encourage their participation more, not just encourage, to ask them to be maybe even be more proactive, to insist on sitting on national security legislation cases in the Court of Final Appeal. That you would have thought would be the positive approach. But what disturbs me is when I hear and I read that the Foreign Secretary of Britain, Mr. Raab, Dominic Raab, said that I have talked to Lord Reed. In what context? To ask him whether, quote, whether it continues to be appropriate for him to be sitting. Now, what do you mean? whether it continues to be appropriate. That suggests it is no longer appropriate because of the national security legislation. If that is so, I think Lord Reid will speak up himself, and Lord Hodge. This is political prodding. This is pressure. Said publicly. Did Lord Reid say anything? No, of course not. Right? He's a judicial person. He sees for himself, he will speak for himself. But this sort of pressure by the British government to the leading judges of England, basically telling them, don't participate, right? It's part of our foreign policy. We are part of the Five Eyes. We will do what America does. That is wrong. That means that such actions lack legal integrity. And that is the main thing that you want from government, is integrity. Whether it's political integrity, legal integrity, intellectual integrity. Be honest. Don't be dishonest about the situation. Make the issue clear. Then it will be a constructive approach. This action is damaging Hong Kong. I mean, do you engage in Hong Kong? Simply say, oh, we think Hong Kong is just another mainland city. Well, I don't care whether it is so or not. I don't care what 7 million people say. We will now destroy the whole setup internationally. No longer recognize you as a WTO member. No longer can you say it's made in Hong Kong. No longer can their judges come and help. It's basically hastening your demise without there being any doom in the first place. So, as I have always started saying on this platform, the main point is, let's see what the issues are clearly. And on that note, I'll ask Simon Young to come in and speak and tell us something about the national security legislation from his perspective. Simon, thank you.
Right, thank you very much, Alan. It's an honor to be here. Alan, you've asked me to talk about some of the international aspects of the national security law.